Data protection. One of the first data protection laws was passed in the UK in 1984 in order to balance protecting individual privacy versus organisational requirements for data in business. The previous Data Protection Act is based on an outdated European legislation passed in 1995. Think about how much technology has changed since 1995 and the new ways our data can now be collected and stored. We put so much of our information online and it's accessible in a way that it's never been before. The use of computers, electronic data, social media and the internet, while immensely beneficial, also provides additional opportunities for data to be accessed, lost or misused. The Data Protection Act 2018 controls how personal information is used by organisations, businesses and/or the government. It implements the General Data Protection Regulations, also known as the GDPR, and makes UK law fit for the digital age, in which an ever-increasing amount of data is being processed. It strengthens the earlier laws and gives individuals more rights over their own data. Key data protection definitions. Personal data. Personal data is any information relating to an identified or identifiable living individual. For example, a name or surname, an email address, card number, location data, or even an IP address. Special categories or sensitive data. This is personal data that is more sensitive due to the significant impact it could have on an individual if it was misused, altered, or released. E.g., race, financial data, political views, religion or belief, and/or sexual orientation. Data subjects. An individual whose personal data is held is known as a data subject. This can be from consumers, customers, contractors, employees, and students. They are all data subjects. The rights of the data subject. Organisations have an obligation to ensure that an individual's rights are not infringed at any time. There are 8 individual rights enshrined in the GDPR. These include the right to be informed, the right of access, the right of rectification, the right of erasure, the right to restrict processing, the right to data portability, the right to object, and right in relation to automated decisions making and profiling. GDPR compliance increases the accountability schools and organisations have and the power individuals are guaranteed with their data. It's one of the most important features when it comes to successfully safeguarding children and young people. GDPR means that schools have a greater accountability for the data they collect. Therefore, any action taken that doesn't fit within the normal school procedure requires full consent, especially if any data is handled by a third party. Furthermore, schools and colleges are required to ensure their third-party suppliers are GDPR compliant and that all transactions are done with a legally binding contract, and all data breaches which have a negative effect on the subject must be reported to the Information Commissioner's Office, ICO, within 72 hours.